Hi, everybody. This is Dave Stouts from Husch Blackwell. With me here today is Malia Rogers. And we'd like to start off by, thanking you for joining us here today for this webinar. I know we've got a lot of people who have been with us on our past webinars, and a lot of people who are new to this webinar. We appreciate you attending for sure. I know it's sort of been a long journey with all this California stuff, and here we go. It feels like deja vu all over again, right, with the CPRA 2.0. I'll say is we've got a ton to cover here today. I do want to start off with just some initial housekeeping items. CLE credits, we've applied for CLE credits in a number of jurisdictions. I couldn't tell you what jurisdictions those are, other than I know that we have. I do know that we are doing something new for this webinar, which is we are offering CLE credit in Kansas. But because of that, we have to do poll questions, which will appear at the end. So if you're in Kansas or you need Kansas CLE credits, hang tight. When we get through the entire presentation, there'll be 3 poll questions. I promise to do my best not to screw that up, but we do need you to hang on to get past the finish line there. For those of you who have attended previous webinars with us, you should feel free to ask questions. Obviously, as we go through the process, it's not always possible for us to answer the questions, but we'll do our best. If we don't, we'll try to follow up with you. And I say, too, this is dense law, and there's a lot going on here. I imagine you'll have questions, and I imagine we'll be answering a lot of those, not only afterwards, but through a lot of blog posts to come in the future and future webinars as well. All right, with that long introduction, let me turn to the roadmap. I think if you've attended a webinar in the past, I like to start with a roadmap. I think one of the big differences on this webinar is my roadmap is incredibly long here, obnoxiously long. So let me sort of level set, right? We initially set this webinar for an hour. And then we wrote the slide deck and said, oh my gosh, we can't do this in an hour, right? And I'll even say, we push it to an hour and a half, and I'll even say even in an hour and a half, gosh, we're covering maybe 75% of what's in there, but the big ticket items, right, as you would expect. If you can't stick for the whole hour and a half, you will get a recording afterwards. So, stick for what you can and then maybe pick it up later. But it really is that challenge, right, where we want to make sure you guys get the information that you need, but at the same time, we want to try to not, overstay our welcome, so to speak. So, the roadmap, those are the things that we're going to talk about today. And, it's a long bill, or a long act, I should say, the CPRA. Some people have said it's 52 pages long. If you go on to and you Google Prop 24 and you actually have a QR scan code in a second to do that, you'll get a 2-column document that's 34 pages long. It's a red line of the CCPA. There's a ton to unpack here. Say as well, sort of like a preparatory comment, the polling that we talked about in previous webinars, this was polling according to the rights group by Alistair and Taggart, was polling in the 70s and 80s% of approval rating. We didn't see that on election day. Instead, on election day, we saw, and I looked at the numbers this morning, that this got about 56% approval, and about 44% of people said no to it. Not necessarily close, 8 percentage points, but certainly a lot closer than we anticipated. And I wonder if the length and the complexity of the law, heck, I'm going to talk to you guys for an hour and a half on this thing with Malia, and, we've got a big background in privacy law, and even we're telling you along today there's a lot we're going to have to unpack here. And I wonder if that complexity really worked against it. Okay, 5 biggest changes then. We want to start with this, and again, kind of recognizing that we've got a lot to unpack here, we thought maybe flagging for you guys the 5 biggest changes at the beginning would make sense. And you can, on the top right corner there, you can scan for a red line of CCPA for the CPRA as well. So just use your camera function on your phone. You can scan that. You can pull up the text. That's always a question we get, right? Is there a red line out there? There you go. It's right there. So 5 biggest changes. Listen, I've been jumping up and down about number 1. And anybody who's talked with me about this knows I've been jumping up and down about number 1, the creation of the California Privacy Protection Agency. We're going to dig into that pretty early, so I don't need to go into it any further. And this expanded contractual requirements, once you start pulling back the onion here, you can really see that there's going to be a lot of work to be done with companies with the expanded contractual requirements. This is not the CCPA with the service provider, situation. This is going to be, onward transfers. You're going to have to seriously think about this. And then we'll get through the rest as well. Number 5, I think, is something that of note. We'll get that in a second, but the absence of a 30-day cure period is I think, going to be significant as well. Okay. With that, let me introduce Malia Rogers, turn it over to her. She's going to take you through the implementation timeline, which I think is probably also top of mind for a lot of people.
Yeah, so as compared with the CCPA, there is a little more time baked in here to finalize regulations, allow businesses to drive compliance. But as we've experienced with GDPR and CCPA, now is the time to start. As you'll see as we go through this material, there's a lot of significant changes to your compliance programs. Bottom line is we have 2 years until January 2023. However, of interest for everyone on the call, immediately effective is the extension of the exemptions for business-to-business and employee data. That's been extended until 2023 as well, so a little more time regarding those type of consumers you might have. So what do the next 2 years look like? Once the votes become certified, shortly thereafter, that's when the CPRA, quote-unquote, becomes effective. And that basically means that the funding and establishment of that privacy protection agency is going to begin. So basically, as early as December, we can start to see movement there. And then the agency will have about 6 months, so till the middle of next year, before they take over the regulatory functions from the California Attorney General's office. The agency is then going to have a year in which to produce final regulations under the CPRA. And then a year after that is when they can begin enforcing it. But businesses have 2 other dates to look at. January 2022 is the date in which the data you start collecting on or after that date will then be subject to the CPRA when it goes into full effect a year later. So there'll be a 12-month look-back period once the CPRA becomes fully operative come 2023. So I'll hand it back to Dave to start to dig into the big changes, beginning first with the Privacy Protection Agency.
Yeah, thanks, Malia. And before we leave this slide, just to point out a couple of things, right, that we'll talk about today. One is the CCPA is still in effect, right? So there's no gap here. There's no we're done for 2 years, right? The CCPA is in effect. And actually what you're looking at is an incredibly difficult situation, right, because you have to comply with a law that you know is going to change, right? And so you're standing up essentially 2 compliance models at the same time, which is tough, right? The second thing I wanted to kind of point out is, that reflexive, I've got 2 years, right? So you're telling me I've got 2 years, right? We know this. We know this time frame. We know this from GDPR. This was sort of kind of the way CCPA worked out, although the regulatory process got really gunked up there, right? 2 years is a lot of time, but it's also not a lot of time when you look at what this is going to require. And if history is any indication of the future in that regard, companies are going to be mindful not to wait until the last minute and try to do what happened with GDPR, which is you just try to do it all in the last month. That's not going to work. So I think, lots to be done in the next 2 years, point being. Okay, California Privacy Protection Agency. So, what is this, right? And if you've attended our previous webinars on this, you've heard some of this, right? There's a lot to unpack with this. Essentially, what the agency is primarily going to take over is the enforcement. Not all of the enforcement. There's still going to be aging enforcement. But the agency is going to take over the administrative process for enforcing the CPRA, right? And this is significant. The reason I'm jumping up and down about this is the big knock that we heard on the AG's office with respect to the CCPA is they don't have the resources to enforce this, right? Now you have an agency who is funded to the tune of $10 million a year once it gets fully operational, who will have staff dedicated to doing just this, right? And there's been knocks about, hey, there should be a private right of action, there should be, it should be up to plaintiff's attorneys to enforce these rights, those types of things. The CPRA doesn't give that to you. There's still a private right of action with respect to data breaches. We'll talk about that later. This is what it gives to you. And this is significantly moving the bar higher. It's not as high as the bar that the privacy advocates want, but it is certainly going to be more than what we have today. And I think it really just does, if all we come down to when we do compliance efforts is risk, right? Cost and risk analysis, those types of things, this ratchets up the risk, period. There's a hole in you can look at Prop 24 and the text there. Proposition 24 was the CPRA, so I might refer to it sometimes saying Prop 24. But you can look at the text of it and you can see the whole shakedown of how the agency is going to work with the administrative process there. But just some highlights to pull out is, 38-day cure period, I mentioned that before, it's deleted, but the agency does have discretion to provide businesses with a time to cure the violation. There's a 5-year statute of limitations, which is a fairly long period of statute of limitations when you think about it. And the ability to seek the opinion of the Attorney General on how to comply has been deleted. I don't know that that's been something that's been aggressively used. At least there hasn't been anything publicly done. The process then for this administrative one, just to give you a little bit more context there, it's going to be like a probable cause process, right? So you still will have the hearing with the agency on probable cause to establish that. So there is still going to be a notice aspect to this process. It's just not going to be the straight up 30-day period to cure where they have to provide notice and then give you time to cure. But there is going to be some time period built in there, but it's not the same as it was before. To also give you just a little bit of context around, actually I'll come back to that in a minute. Let me give it this to you first because I think it helps complete the circle here. With respect to enforcement, I said before the agency is going to enforce this, but it's not going to be the exclusive enforcement agency. The Attorney General's office still retains enforcement authority, right? And it's essentially, the agency is going to bring administrative processes. There are opportunities for civil actions, but primarily the AG's office still has this enforcement authority. How much they exercise that remains obviously unclear, but it's still there. And, before there was a lot of talk when the CCPA went into effect about whether district and city attorneys can bring actions under the CCPA. There's some language that got deleted in the CPRA, and McTaggart has said that this will allow, that was intended to allow district and city attorneys to bring actions as well. So a lot more enforcement mechanisms in general. Some of the other functions that the agency will do, rulemaking. It will take over rulemaking authority from the Attorney General's office, right? Malia showed that to you on the implementation timeline. And if you look at the rulemaking, something we'll talk about later, you're going from 7 topics of regulation to 22 topics of regulation. 3 times the amount of regulations. That agency is going to have its hands full. If you thought the rulemaking process was complicated the first time around, I can only envision what we're up against this time. When you think of the fact that the comments and the appendices to the rules were hundreds of pages long, I mean, it's just going to be incredibly complicated. The guidance process as well remains to be seen how far the agency will take this, but there is an aspect in the CPRA talking about providing guidance. And I wonder if that will ultimately end up something close to what the EDPB does in the European Union, where it publishes guidance on particular topics. Remains to be seen. We'll wait and see. The audit function, hidden in the regulations, is the ability for the agency, when I say the ability, the requirement for the agency to appoint a chief privacy auditor to ensure compliance with the CPRA. And that auditor will have subpoena authority, right? And so now it's not only going to be that they're out there enforcing it, it's also that they have a duty and an obligation to also perform audits on businesses, right? Think about that, right? And to kind of put it in context as well, Malia actually pointed this out to me yesterday, and I think it's exactly right? California is the 5th largest economy in the world, right? And now you're going to have a functional data protection authority for the 5th largest economy in the world, with an auditing function, a rulemaking function, and an enforcement function, right? McTaggart's been on record saying that he thinks that this will be the most powerful data protection authority in the world. I don't know. I mean, what can I say, right? It remains to be seen. But I don't think that he is. I don't think he's out of his depth for saying that, right? And also to kind of give you another frame of reference as well. Next year, the FTC's Federal Trade Commission. I looked at their budget for next year. They are asking for 61 full-time equivalents to be budgeted for privacy and incident response next year. 61, right? McTaggart has said that based on the budget in the CPRA, he expects there to be 50 full-time equivalents out of the with the agency. So point being is, this is a big deal. It's a big deal. It looks like the next slide is displaying poorly. So let me just kind of talk you through that. Sorry about that. I'm not sure why that is. This is the structure of the agency, and I'll just give you a brief overview. 5-member board of it. The governor appoints 1 member. The AG, Senate Rules Committee, and Speaker of the Assembly also appoint members. The governor also appoints the chair as well. And Malia mentioned this before, but the initial appointments are within 90 days of the effective date. So this is something we'll see in the next few months, 90 days of the effective date. For those of you who are preparing your applications, you have to be California residents to apply. And there are requirements in the CPRA for the skill set that is required to get in here. But I think the takeaway from this one is you're going to start seeing movement, right? You're going to start seeing blog posts about people who have been appointed to head up this agency. Okay, so let me turn it over to notable definitions, and you're going to hear from Malia again.
Okay, so we'll obviously be calling this out as we go through the various topics that we outlined from the get-go, but we wanted to flag a few that are kind of threshold definitions. So the first being that the definition of a business that's subject to the CPRA has shifted slightly. If you were one of the businesses that got swept up into CCPA compliance as a result of processing the information of 50,000 or more California residents, households, or devices, the CPRA now doubles that threshold to 100,000. Interestingly, that was actually how the original CCPA initiative was drafted. So they're just kind of returning to that idea of targeting these big data brokers, and found that some of these small businesses were easily meeting this 50,000 threshold simply by collecting credit card information. So trying to move away from that. Also pro-business here is they've removed the reference to devices. So it's going to be 50,000 or more consumers or households. So in 2 years, it's possible that some businesses will no longer be subject to compliance under the California law. We also wanted to just call out there are a few additional changes related to this idea of what a business is. There's a new definition for joint venture, which is in the material that you can read. There's also changes to language in the provisions dealing with entities that are under common control or branding with businesses that are otherwise subject to the CPRA. And then there's this new concept of voluntary certification. Not clear necessarily the intent of this, perhaps foreshadowing adequacy decisions from abroad, but more to be seen on that. What hasn't changed is equally important. If you are a nonprofit, this CPRA will still only apply to for-profit entities, and publicly available data is generally still exempt from the CPRA. However, they have expanded the definition of what publicly available means. It now includes information that's made available to the general public or is otherwise made available to another person or entity by the consumer. So it suggests that, at least privacy advocates are stating it suggests that this is going to allow for data scraping, but it at least provides a little clarity around those social media platforms such as LinkedIn or otherwise where consumers are, voluntarily putting their information out to the public, absent any sort of privacy setting. So looking at this as a very pro-business change again. And now I'm going to flip it back to Dave. He's going to go through, I think it's our fifth topic, which is another big one, which is the expansion of contractual requirements.
Yeah, and I think you see with Malia's comments before, one of the biggest challenges in this whole thing is to stop saying CCPA and start saying CPRA, right? I mean, that's why I think we've been calling it 2.0 sometimes. It's hard with all the privacy acronyms here. So we're trucking along here. Hopefully you're sticking with us. Expanding contractual requirements is our next topic, right? I do think this is a big deal. CCPA, right? So CCPA has the concepts of third party and service provider. And you guys know these already. Service provider, you've got to say 3 things in the contract. You become a service provider, and you're good to go, right? It's not a sale of personal information. The CPRA adds a new category of contractor. So service provider feels a lot the same, and that is a person who processes personal information on behalf of the business for a business purpose pursuant to a contract, and we'll talk about the contract stuff in a second. Contractor is somebody who the business makes available to PI. There is a definition of process in the CPRA. There is not a definition of makes available in the CPRA. So if you're in the Q&A asking me what makes available means right now, I'm still thinking about it. And I think some of that's going to have to do with what we talk about in the next few slides as well. Third party is everyone else. So one of the things they did, if you look at the statute itself, or I guess statute, law, act, whatever you want to call it right now, is they deleted most of the definition of third party and moved that into service provider and contractor, which makes logical sense, right? It just didn't quite, the way that they set up the third party definition was basically a third party is everyone who doesn't do X, right? And they listed that doesn't do stuff. They moved that into the service provider and contractor, cleaned that one up. But third party is essentially the default category. Okay, so expanded contractual requirements. CCPA, said it before, you guys know it well, I imagine, service providers. You need a contract if you want the entity to be a service provider. CPRA, you need it if you're selling or sharing PI with a third party. We'll talk about sharing in a little bit. That's a new term here. But you need it if you're selling or sharing PI with a third party. That's new. But you have to have a contract. And if you disclose PI to a service provider or a contractor for a business purpose, right? So you've got a lot of different instances in which you're going to be needing contracts. I don't know that it's going to be every instance because you can get into the exceptions to the definition of sale. But long story short, this feels a lot like Article 28 GDPR, right? I think people are really going to have to be spending a lot of their time thinking about what category their business relationships fit into and whether they've properly documented them with contracts. And we talk about like this whole, hey, you've got 2 years, but don't waste time. This is something I think is going to take a lot of time. You've got to, obviously inventory your third-party data transfers, figure out where they fit into, and negotiate those contracts. So all contracts, so this is all those transfers I talked about in the previous slide, have to do certain things, right? And here they are. And I should say as well, I don't know if we pointed this out, but one of the things we tried to do for you guys, in the bottom left-hand corner of the slides, we put the statutory references. So if you go back to that QR code that allows you to scan, you can pull that up and then you can look and you can see where these things fit in, right? So we try to do that. Obviously, it's a fairly dense statute. We wanted to connect the dots for you there. So every contract, right? So this is the contract, the service provider, the contractor, and the third-party transfers we just talked about in the previous one. You've got to do these 5 things. You got to specify the PI that is sold or disclosed, and the purposes, obligate the other entity to comply with applicable obligations and provide the same level of privacy protection as required by CPRA. It's ambiguous, right? I mean, applicable obligations. What does that mean? It's not further defined, and I think it's gonna be something we think about for the next 2 years. Grant business the right to ensure the other entity complies. Require them to notify you if they cannot comply. And then grant the business the right to stop and remedy the unauthorized use. And listen, the next slide's going to show you service provider and third party stuff, what those need to say. It goes beyond, but this is 5 things. That's all these third party transfers. And I think, as you guys know, once you start getting into the process of working on data processing agreements, you start adding a lot more other things as well, right? So this, I think, is something that, again, kind of feels a lot like Article 28, and I think it's something that's going to really be a lot of work here. Okay, so that's all transfers. If you are a service provider or contractor and you want these people to be a service provider or contractor, you've got to do 4 other things. So here's the first 2. 1, business purpose. It's got to be done for a business purpose, and the definition of business purpose has changed. 2, the contract has to prohibit the other entity from doing a few things, right? 1, 2, and 3 there, selling or sharing, retaining, using or disclosing, and then second, retaining, using or disclosing. Those are the same as service provider now, right? You'll recognize that language. The last one, combining personal information with personal information it receives from other sources, is new, right? And I think that's going to be something that's going to need to be fleshed out there. There's an aspect of that that has some exceptions, like I said there. But again, something that I think it's also open for regulatory rulemaking as well about those exceptions. That's going to be something interesting, especially when you think about SaaS providers and cloud storage and all that type of stuff, okay? And then the last 2 requirements, the use of sub-processors. So, I mean, if you track this, right, you know the CCPA doesn't even envision sub-processors, but when the regulations came out, they started allowing entities to actually transfer a PI to sub-processors. But now we've got this concept of notifying the business and then having the sub-processor contractually agree to the same provisions, right? I mean, if you're familiar with Article 28, you see where this is coming from, right? Monitoring compliance is not the most well-written aspect of the CPRA. We've gone over this language. It is different language as between the contractor versus the service provider, and it is not abundantly clear whether this is mandatory or permissible. And I think we'll sort of leave it at that, and we'll probably go through and write blog posts on this in the future. But this is sort of that auditing function. If you've done the Article 28s in the GDPR context, that's here. But again, the language here is just, I don't feel comfortable right now saying it's required because there's the word may appears in the service provider definition here as opposed to contractor where it doesn't appear. So more to be figured out there. And I talked a little bit about the changes to the definition of business purpose. There are, and as we go through this in the next couple of years, we're going to have to be looking at this, and they're primarily around the concept of advertising. There's addition of new concepts there, and a lot, as you imagine, right? I mean, a lot of the CPRA is around this concept of sharing and selling personal information to third parties for advertising purposes. And so, as you might imagine, the definitions around that have changed. So, point being, as we navigate this in the next couple of years, looking at those business purpose definitions is going to be something worth taking a look at. Safe harbor for transfers. This is something that will be interesting to see how it plays out here, right? So the concept is, and this is something that's in the CCPA, fleshed out more in the CPRA, but if a business transfers personal information to other entity and that other entity violates the CPRA, there's a safe harbor, right? You can't, the AG's office or the agency can't come back on the business and say, hey, you violated this, CCPA now, CPRA later, because it was your contractor, your service provider, your third party, right? But you can't know or have reason to believe at the time of the transfer of the violation, right? And then, the third-party safe harbor is subject to certain limitations, so that's that other category of contracts we're talking about. And I've got a for example there. Point being is I look at this as well, and plenty to flesh out over time here, but I look at this as really pushing businesses to enter into contracts, right? And because it'll allow for you to have a safe harbor provision for transfers. Okay, changes to existing rights. Is this still me? I mean, this is still me?
Still you, Dave.
Okay, still me. Right to deletion. Still got it. Still there. Slightly different. CCPA, left column. You got to delete the information and direct your service providers to delete the personal information. The change in the CPRA is you got to delete the information and notify service providers or contractors to delete the personal information and notify third parties to delete that information unless impossible or involves disproportionate effort, which is a new concept introduced by the CPRA. The exceptions, I think this is still me. Okay, still me. Right to deletion. Still got it. Still there. Slightly different. CCPA, left column. You got to delete the information and direct your service providers to delete the personal information. The change in the CPRA is you got to delete the information and notify service providers to delete the personal information and notify third parties to delete that information unless impossible or involves disproportionate effort, which is a new concept introduced by the CPRA. all of the exceptions are now, and like we talked about this for 2 years, right? You have the right to deletion, and you've got all the exceptions to the right to deletion. And basically, the reality was you could probably find an exception that applied, right? Given how they were worded. And so I think they've tried to tighten that up a bit, right? So reasonably necessary is introduced. All the exceptions must be reasonably necessary. The change to exception 2 is the same. If you remember a couple slides ago on the business purpose, they've replaced the detect security incidents, business purpose, and exception here to that language there. And then they deleted exception 9, which I think actually will come into play a lot because that was this sort of like catch-all. If no other exception applied, we could look to this one and see if it fit into this one. So they deleted that, and I think for obvious reasons. Okay. This is Malia.
Yeah. Well, and to comment on the deletion aspect, that is kind of a bigger shift that McTaggart and them were promoting in the sense that there's now this chain of custody obligation for businesses. I mean, that makes sense given the contract requirements, but now, you have to know where that data is going and be able to notify all those third parties and service providers. So
yeah, and that reminds me, there are provisions in the CPRA that talk about like service providers and what they shall do in response to requests. We're going to hit those later, but that'll be something to think about in a second. Yeah,
and so with the right to know, there's this additional concept which Dave is going to tease out in just a minute, but this idea of sharing data with third parties. And basically this new term, it's going to concern marketing concepts of cross-contextual behavioral advertising, but basically this is going to come into play with your right to know and your right to opt out. So it's expanding the disclosures that you need to make and in response to consumer requests to know. So you'll need to include what information you're sharing in your privacy policy, and the third parties with whom you're sharing it, and when a consumer exercises their right to request to know what information is sold or shared, you have to tease that out a little bit here as well. Similarly, with the right to opt out, it now extends to the right to opt out of sale or sharing. Consumers can not only opt out of information that's sold for monetary or valuable consideration, but also this new cross-contextual behavioral advertising. And then there's the same opt-in requirement for those who are under the age of 16 when it comes to now not only selling their information, but if you are sharing their information, it requires an affirmative opt-in. So I'll let Dave go into the selling and sharing.
Thanks. I think you forgot to advance the slide before, right?
Yeah.
We'll give you a pass. So hey, good news. Your reward for spending the last year plus trying to figure out what selling means is now you get to figure out what sharing means, right? So let's do it this way, right? Let's just kind of put them up next to each other. Sell on the left side, share on the right side. So sell is a transfer to a third party, so is a share, right? Sell is for monetary or other valuable consideration. I hate to disappoint you. The CPRA does not define monetary or other valuable consideration. We still are on the search for that definition. But share does not require monetary or other valuable consideration, which is kind of interesting, right? If we have trouble defining what is other valuable consideration, now we're going to have to say, what does not, right? And sharing is for cross-context behavioral advertising as well as in the definition. So anyway, so selling has stayed the same, right? And sharing is basically transfers, whether or not for monetary or other valuable consideration, for cross-context behavioral advertising. It looks like I did not make the footnote subject to same 5 times the size of the regular stuff. It looks like the platform's having trouble loading the slides. It says there subject to same exceptions, right? So if you look at the definitions of these two concepts, they by and large track one another, except for these differences here and the exceptions as well, right? So we talk a lot about the first exception to sell, right, which is intentional disclosure, and I'll talk about that in a second. But that's the same. It's the same exception to the definition of share. Okay. All right. Cross-context behavioral advertising. Like I said, this is something that is in the definition of share. That distinguishes it from sell, one of the two things. And here it is, pulled out from the CPRA itself. It is exactly what this is. You guys can read it, right? It's across businesses, though, right? So you're thinking like tracking technologies and the like. Okay, and I foreshadowed this before. There are changes to the exceptions to sale and share that are important. In the CCPA, that is the general requirement there. It's not a sale, and this is the first exception, right? I'm only focusing on the first exception, not on the other ones. The first exception is the one we spend a lot of time thinking about with clients, right? It's not a sale if the consumer uses or directs the business to intentionally disclose personal information or uses the business to intentionally interact with a third party, provided the third party does not also sell personal information, unless it's consistent with the CCPA, whatever that may be. The CPRA streamlines this, right? It's not a sale or share if the consumer uses or directs the business to intentionally disclose the PI or interact with one or more third parties, right? So it gets rid of that blue, italicized, bolded clause of provided the third party does not also sell PI. So, people are thinking cookies, right? And tracking technologies, cookie consent banners. I think this really, we talked a lot about in the past. We've written a lot about that in the past. I think this gets it a lot closer to what business would want, and through the use of cookie consent banners and the like. Okay. The right of no retaliation following opt-out or exercise of other rights. This is like the right of not you can't discriminate for exercising the rights, right? So it's been rephrased. It's very wordy now. Obviously, I'm tripping over it. Some additions here: you can't retaliate against an employee, applicant for employment, or independent contractor for exercising their rights. The second bullet point here really is what the new aspect of this is that privacy advocates were up in arms against. In particular, it just says it doesn't prohibit businesses from using loyalty programs, reward programs, et cetera, right? This was a big fight back in the day. You'll remember this, 2 years ago when they were going through all the amendments on the CCPA, and they got to this provision here, and they changed one word in this provision, which was like, the value to the business versus the value to the consumer of the personal information. And privacy advocates were upset about that, but there was still this opening about whether or not loyalty programs could work, because you're functionally in a loyalty program, you are functionally paying for people's information, right? You get discounts because you're willing to track purchases and the like, right? So this just allows for, right? And McTaggart, I think, I've seen him speak on this. He just says, yeah, we just accepted the reality that everybody does this, right? And now the CPRA says it. Okay. Moving on, new rights, and that brings us back to Malia.
So shifting now to what is brand new come the CPRA. Not so new in the sense that if you're familiar with GDPR, a lot of these consumer rights are kind of meant to mirror what we see in GDPR. First is the right to correct inaccurate information. It's pretty flexible, though. It has some parameters such as taking into account the nature of the information and purposes of the processing. It also doesn't go quite as far as GDPR Article 16, which affords data subjects the right to have incomplete information completed. But this is a pretty slim new provision within the CPRA. Not much else is said. And we're going to be looking to the regulations to set the standards regarding how often consumers can exercise these rights, under what circumstances. There's also this same new concept that we've seen in other areas of the CPRA, which is balancing that with any sort of disproportionate effort or whether it's impossible for the business to comply with these rights. And this is particularly a concerning right, perhaps in the employee context. how far this right will go in terms of personnel records, et cetera. But yes, more to come there in terms of regulations. This is also a verified request, so similar to your right to know and right to delete that you're currently complying with, you're going to have to verify this consumer's identity and comply with their request using commercially reasonable efforts. So again, a new twist in the CPRA, likely to be clarified in the regulations, and do so within 45 days to respond. And Dave will go in more later to responding to verified requests.
Can't wait.
Another new right is, well, we're phrasing it as a right, which is the right to limit the use and disclosure of sensitive personal information. This is a new concept in the CPRA, this new subcategory of sensitive personal information, but there's basically more protection afforded to these types of data. Consumers currently have the right to know what data is collected about them, have it deleted, opt out of sharing of it. This is now a right as to how a business is using this data. It's a new ability to stop the use of sensitive personal information. But it's somewhat limited. There are permitted purposes for which a business can use sensitive personal information. It's pulled from the various types of business purposes that we're already familiar with seeing in the CCPA, ensuring security, a short-term use, providing certain services that would be reasonably expected from an average consumer. If you're using the data to verify or maintain the safety or quality of whatever your service or product is. So if a business is using that data strictly within these limited permitted business purposes, then you don't need to provide this right to consumers. To the extent you use sensitive personal information outside these limited purposes, that's when you're going to have to provide notice of this right to consumers and allow them to limit your use to those permitted purposes. What is sensitive personal information? It's derived from GDPR in the sense that we're used to seeing some of that demographic or diversity data, genetic data, biometric data, but it's more comprehensive here. It goes into even the contents of your personal emails and a lot of the information that we're familiar with seeing in terms of identity theft concerns, so government-issued IDs, account details in the financial sense. But as with personal information, if any of these categories of information are otherwise publicly available, as we discussed earlier, then that information is not going to be treated either as sensitive or even personal information subject to CPRA.
It's going to take time.
It is. Also, precise geolocation is considered sensitive personal information, and it brings an end to the ability for businesses to track users really at the household or room level, which is capable now. By definition, precise geolocation creates this radius of protection or anonymity. The math shows that it's about 250 acres or a third of a mile, and more regulations might come out, depending on if that's effective. I think there's some suggestions that maybe in rural areas that still might not be enough of a protection. But you'll still receive ads as a consumer. It's just not going to be able to track you at a precise location. If you are subject to having to disclose the right for consumers to limit your use of their sensitive personal information, meaning you're using that data outside of those limited business purposes, unfortunately, you will have to add yet another prominent link, limit the use of my sensitive personal information, in addition to, and separate and apart from a do not sell my personal information. So, not business friendly in that sense. There's also an exception to what constitutes sensitive information besides the publicly available, which is information that's processed without the purpose of inferring characteristics about a consumer. Still a little unclear as to what this is getting at. Again, it's going to be important over the next year and a half to be monitoring the agency and the regulations that they're setting forth. The notice of collection, so this is just going to be a shift similar with personal information in your privacy policies. Now this is a new subcategory, so you're going to have to list those explicitly as well as who you are or how you're using it, regardless if it's within those limited business purposes. So speaking of notices, there's a few additional obligations on businesses when it comes to what needs to be disclosed in those notices. We frame these as consumer rights, but really they're more business notice obligations. There's no real process or format for consumers to exercise these rights. So this right to storage limitation, you'll have to disclose how long you are retaining information and provide this notice, and it has to be reasonably necessary for the disclosed purpose. So if you're not able to pinpoint the exact data retention period, you at least need to be providing criteria by which you're going to be determining such period, and it needs to be reasonable. And then there's the right to data minimization. It prohibits businesses from collecting more information than is necessary. Again, we're seeing some flexible language. It has to be reasonably necessary and proportionate, so it's not a one-size-fits-all. There's arguments to be made on both sides likely, and then there's some protection that disclosed purpose in a notice. Any further purposes have to be compatible with what was originally disclosed. Obviously, privacy advocates are upset from the aspect that this is from the business's perspective, and the concern that businesses can list all sorts of purposes and give them great flexibility in how they use that data. But at this point, it is at least requiring businesses to come up with data retention policies and have to disclose that. So if you haven't already done so, this is one of those steps that makes sense to start taking now and cleansing your data and building out data retention policies, whether it's based on your legal record requirements under state or federal law, if there's certain claims that you need to be aware of for statute of limitations or other business objectives that you might have. And then we wanted to flag one other right, if you will. This is not explicitly stated as a right in the beginning sections of the CPRA. It's buried in the regulations with a lot of other stuff, but there's this new right for consumers to object to automated decision-making processing and to actually understand or have a business disclose to them the logic behind that. And so this has been explained kind of if you're seeing, like, why are you seeing certain job listings? Is it because of your health status? Is it because of certain demographic data? But basically, this idea of profiling is contemplated in the CPRA and allows consumers more rights. So that is the new rights and brings us how businesses are going to receive these requests, process these requests. So I'll turn it back to Dave.
Yeah, thanks. And Malia said it with respect to that last slide, right? It's buried in the regulations, or the topics for regulations, probably a better way of saying it. And I would just emphasize is if you are reading the CPRA and you get to the part of the regulations, don't stop. There is a ton of stuff in the regulatory rulemaking requirements that does not appear in the other portions of the CPRA. So, dig in there. Don't stop there. You'd be doing this in 25-30% of what's going on here. Okay, so for requests, I think I jumped a slide there. So still, I mean, there's verifiable and non-verifiable requests. The verifiable requests, the right to correct or request to correct inaccurate information is a new one added in there. And, you guys are familiar with the request to delete and the request to know collected and sold. Again, we've added these concepts of sharing, right? So not just sold, but sharing as well. So you're going to be able to make these verifiable requests. Methods of verification, a lot of similarity here, not a ton changed, despite the fact that I have a lot of text on there. There's not a lot that's changed. The tweak I'll point out there is the toll-free telephone number has been expanded for everything. It's required now. Before it was just request to know or access. That's always been a privacy advocate thing, right, about having telephone numbers to exercise requests. Viewed as like a socioeconomic issue. 45 days to respond to the request to delete inaccurate information. It clarified some of the language regarding like the extension, how many days you can get extension. It's 90 total, so you would get 45 days initially, and you could take the other 45 days. There was some contradictory language in the CCPA that the regulations really kind of took care of. But the other calculus is really largely the same. In the verification section, they added another category of people who can get into the verification. We talked about this before. You may recall about half an hour ago I said we were talking about the obligations on service providers and contractors, that there's a little bit more to be talked about there. So in these provisions here, 105 and 130, they require service providers and contractors to do certain things. Cooperate, that makes all the sense in the world, in responding to these requests. Enable the business to delete the information or delete the information itself, correct the inaccurate information, and then notify them. Notify any of their service providers or contractors to delete the PI, right? So that downward transfer aspect as well. They don't still. I mean, this came out of the regs, right? With more clarity here, they don't have to comply with requests submitted directly to them. But they do have to, and it says shall, they do have to provide services to the business to effectuate these requests. 12-month look back. This is an interesting issue. I say 12-month look back no more, and we've always said, hey, CCPA, you've got a 12-month look back period here. Here, it's yes. I mean, it covers a 12-month period, but the consumer can request information beyond that, and the business has to comply unless doing so proves impossible or would involve a disproportionate effort. We saw similar language before, right? And the agency is going to have rulemaking on that as well, defining what that means. And then Malia talked about this before, that right's going to apply to PI collected after January 1st, 2022. Yeah, I mean, when you think back on the data minimization principle Malia was talking about before, this really gets businesses to that point of minimizing their data, right? Minimizing what they have and thinking through all that. That's what you see here. I mean, obviously, if you don't have it, you can't turn it over. If you don't have it, you can't delete it. So I think that's what this is really driving after here. Data portability, it's still there, just moved. So that's where you can find it. It's the same concept as before, cleaned up just a little bit in the language, but it's still there just in case you saw that was deleted in one section, it surfaces in another. Opt-out requests. Malia talked about this before. So you're all familiar with the do not sell my personal information link. What I do want to say is, before I forget, just one point on the CCPA is you may have missed, we've tried to get our clients aligned on this, but in the final version of the regulations, there was a slight change. The regulations were gracious in the sense that they allowed you to say, do not sell my info. And then the Office of Administrative Law came back and said, no, you, Attorney General's office, you do not have any authority in the statute to say, do not sell my info. The link needs to say, do not sell my personal information, right? So we haven't gotten to you yet on that regard. I apologize to our client base, but if, we've been trying to get people make sure that they're saying, do not sell my personal information as opposed to do not sell my info. Okay. Having said that, as Malia said before, the sharing concept's been added. So you're not to say, do not sell or share my personal information in that link. And then there's also this other requirement to limit the use of sensitive personal information, so you're going to have that link there as well. Although there is language in the CPRA that says instead of the 2 links, you can use a single, clearly labeled link on the home page that easily allows a consumer to do both, right? So maybe more to come on that one. I have shades in my mind of, the opt-out button, right? The disaster that was the opt-out button in that regard on that single link aspect. We'll see how that plays out, right? But room on the footer of the website is getting sparse. I know that many of you have already demanded Malia and I for, expanding, telling you that what you need to put in the footer of your website, and it's subject to the single link option. We'll end up seeing what happens there. Okay, there also is a preference signal. I don't get too much into this. There's a lot that's going to come out on this with respect to the regulations. And the concept here is, privacy advocates have said, you're really putting, GDPR puts the burden on the company to have a basis for collecting the information, right? And what CCPA does is an opt-out. It puts the burden on the consumer to opt out, to limit the use of sensitive personal information, to opt out of sales, right? So what if we created so, it was ability for, a preference signal to be sent by the browser saying they want to do these things, right? You're thinking do not track, right? And that's a very similar concept here. So anyway, so this is going to get fleshed out over the next couple years, and businesses will have the option of using this. It'll be required in certain instances as well. It's all got to be kind of fleshed out. There's more to come on that. It's something we're going to talk about for months to come. Privacy policy changes. I think, Malia, you're back up, huh?
Back up. So this is a January 2023 target. Once you've done all the background work on your data and your contracts, your data retention policies, and setting up all these methods of receiving requests, it's all got to go in that updated privacy policy. As we've already discussed, and Dave just went through this again, when it comes to requests, we need to account for this idea of sharing any personal information that's been shared, this new subcategory of personal information, which is sensitive personal information, and then the new rights. So 1 through 4 basically 2 through 4 are basically what is required under the CCPA, just extending that again to sharing of data. You'll have to now include your data retention and rights to correct. And notably, in the list of data that's shared in the last 12 months, it now requires that to the extent you're selling data or sharing it, it has to be prominently disclosed. So if you're just disclosing it to third parties, not so important, but if you're selling or sharing it, there's this new requirement that it prominently be disclosed. And then similarly, your notices of point of collection, we've kind of already talked about the changes to this, but one interesting point is that the CPRA made a shift in stating that notices at point of collection are for businesses that control the collection of personal information. It's significant in that it shifts the obligation to an entity that has the direct relationship with the consumer, even to the extent you're pushing them out to one of your service providers or a platform. It's your obligation as the business who has the relationship to provide that notice at point of collection of the information to be collected and the purposes for which it will be used. And then similarly, new disclosures regarding whether it's sold or shared, whether sensitive personal information is involved, and your additional obligation regarding your data retention. All right, Dave, exemptions, new exemptions.
All right. So, data harvesting outside of California. If you've been on previous webinars, you may know that this was one of my favorite provisions of the CCPA, right? It was basically a business could not lie in wait until somebody crossed the border into Nevada and harvest all the data of the California residents, right? It was like, SaaS providers going to create this this vault of information and then harvest it the minute somebody got off the plane in a different state, right? And so that was what the provision says, except now it says you can do that. You can do that. You can lie in wait. So a one-word change that, really is going to have significant impact there. And, the concept there being, I've heard McTaggart talk about that, right? The concept is, was that a legal requirement? I mean, California can control what happens in its borders. Can it really control what happens outside of its borders? That was the concept there. The GLBA exemption, I know we always have a lot of financial institutions on our webinars, and you're probably, there's probably many questions in the question box right now about what about this exemption. This is it. This is the change in the language. They've changed pursuant to subject to. Frankly, that was a change that's 2 years overdue, right? Because you don't collect, process, sell, or disclose pursuant to GLBA, it's subject to GLBA. So it's a welcome change. And then they added the entities in the system, Federal Farm Credit Act, entities covered by that. So I know that was something that those organizations were lobbying to have added. New exemptions, there's some interesting ones there. I've got them, put a fourth there. And, if any of these look relevant to your organization, I would say dig in to that section 145, parts O to R. I do like the yearbook one. It's partial exemption from the right to delete and opt out, right? I mean, your information's in the yearbook. It's kind of hard to get that undone, right? That makes sense. Student grade, scores, and results, the right to deletion, that's the, I had a bad semester, I want to get rid of that, right? So a partial exemption there. And same thing with like standardized test answers. These things all kind of, strike me as logical, right? Logical extensions that got added, or exemptions that got added. Okay, changes to the private right of action then. Small change here. It's been expanded to email. So the data elements that are covered by the CCPA's exemption track the elements in the information security provision and statute, I should say. And now there's this addition of email, which was added to the data breach section of California law. So this is basically just mirroring up the CPRA with the existing statute, the other statutes, data breach notification statute. The opportunity to cure, litigants are still provided with the ability, they have to provide notice in 30 days to cure before you can have one of those class actions. But there is this new provision in there that, implementation of reasonable security procedures after the fact does not constitute a cure with respect to that breach. So that was, the old issue of could you basically say we've cured because we implemented, end-to-end encryption or something like that, and that was the failure mechanism. Could you do something along those lines? Basically saying no. I mean, the cure would be, I think, well, I don't want to say something, and then come back later, but I think they've restricted the cure ability, let me put it that way. Okay, expanded regulations, some people may say this is burying the lead, right? CCPA, 7 topics for regulation. CPRA modifies some of those 7 topics and adds 15 more. I can already feel the late nights and early mornings reading regulations and comments to regulations and going crazy over all of that, right? High-risk processing buried into regulations, right? And we're just going to tease out a couple things here. But the high-risk processing buried into regulations is if you are an entity that is processing PI that presents a significant risk to consumers' privacy or security, you're going to have to do an annual cybersecurity audit, and you're going to have to submit a risk assessment to the agency on a regular basis. And again, this is rulemaking, right? So more to come on this about what exactly is significant risk to consumers' privacy or security. We can just sort of guess at this right now. I've got some suspicions, but we'll end up seeing how that plays out. But you can, an annual cybersecurity audit and a risk assessment, that's a big lift. That's a big lift there. And again, remember that agency has auditing rights, right? It has the ability to audit. So you can imagine what they're going to do with this. Some other topics that we're going to see regulations on, further defining intentionally interacts. There is a definition of intentionally interacts. there in the CPRA, but they're going to further define that. And I think that, in my mind, I think that's going to be a big aspect with respect to like opening the door for like cookie consent. And you can imagine, right, as we've seen over in Europe with the DPAs over there issuing guidance on cookies and those types of things, maybe that's what they're going to get after there. I've talked about the requirements for the opt-out preference signal. There's just going to be a lot there. I just imagine we're going to have pages of stuff there. And then the last one is actually a fairly big issue, which is resolving conflicts between the CPRA and the California Insurance Code. This was really pointed out, and they got legislation, 2 years ago they had legislation that was put forth that would have dealt with this issue, and it didn't get anywhere. But here, they're charging the agency with issuing regulations on this. So I think that's another good thing for business overall, right?
And just while we're on the topic of regulations, I just wanted to clarify. I feel like there's been a few questions coming in on this idea that the 2022 date precedes the date by which final regulations are going to be required. And so I just wanted to clarify, the CPRA is going to become fully operative, meaning you're going to have these mechanisms in place, these disclosures in place, start responding to these new consumer requests come January 2023. The disclosures you're going to include in your privacy policy and notices, and when responding to consumers, is going to cover what you've been doing with data that's been collected on or after January 2022. But the final regulations are due by the middle of January 2022. So it's going to allow you 6 months from the middle of 2022 until January of 2023 to ensure that your disclosures, your mechanisms, et cetera, are in compliance with the regs. So you don't have to have things in place by 2022. It's just this concept of looking back 12 months.
Right. So January 1st, 2023, we're sitting here. Hopefully I'm sleeping. They're spending all this time trying to get people compliant. But if somebody submits a request on January 1st, 2023, that information goes back 12 months.
Yeah.
That's the concept.
Right.
Right. Actually, and I hadn't thought of it until now, but I mean, there is that slide we had on 12 months, no more, right? So the regulation is going to tell us what those conditions are as well. So we'll wait to be seen. Yeah, lot to unpack here. Lot to unpack. You want the next slide now?
Yes. So given all these changes that are going to be coming over the next 2 years, what are some of the steps that we recommend you prioritize now? Again, clarifying in terms of this implementation timeline that the CCPA, the regulations issued by the AG's office, that is the law right now, and that is enforceable by the Attorney General. So still drive compliance towards those. We still might see more regulations. In fact, they just received comments on some amendments to the final regulations at the end of October, so we'll see if those come into play. So the CCPA is still in force, and you still need to comply with it, even if you're going to be one of those businesses that come 2023, you are no longer subject. So second, that's this idea that is the CPRA going to be applicable to you? So really digging into the changes to the defined terms for business and the subcategories of business, and whether you're under the direct control of maybe a business that is going to be subject, even if you yourself, your business might not be directly subject or hit one of those 3 thresholds under the definition of business. And then the data, like I said, collected on and after January 2022 is really what's going to be focused on when the law goes into effect the year after. So taking a foundational step to map your data, really clean up your storage of data, deleting unnecessary data that you no longer have a purpose for maintaining or processing, should ease your compliance obligations when 2023 comes around.
And on that, before we move to the next topic, Malia, I think there's a lot to be said too. I mean, this is not this is not as prescriptive as you see in GDPR, but privacy by design is something that everybody should be thinking about, right? Is instead of being reactionary with a lot of these things, and you can see how California, how this has really expanded things, right? There's a lot new here. There's a lot to digest, right? And what we hear from clients all the time is we don't want to be reactionary. We want to be, get ahead of it, right? I think instituting privacy by design principles over the next 6 months to a year would be monumental to getting you across the finish line, right? What data are you collecting? Do you need that data? What's the purpose for that data? And starting to roll that out with your business units of thinking about, going through that process so that you're not always just clutching for straws along these lines. And that is, I think, a huge aspect of mapping data and deleting unnecessary data, having some check and balance, right? I mean, how many times have we dealt with clients where they come to us and say, it's X, Y, and Z, and we say, why do you need to collect this data element? We don't. They're just offering it. Okay, well, understand if you collect this data element, what this means for us long term, right? And to be able to catch those in the next couple of years, I think would just be substantial. That's something I think everybody can kind of get over. Get their heads wrapped around, I should say. Okay, number 4, you're back up.
Yeah. Well, and all of this is building towards any other states that implement privacy laws,
sure.
Washington, et cetera. So it's not a lost cause. Number 4, because of these contractual requirements, not only with your, direct vendors, service providers, but now with all third parties, really need to identify your third-party relationships, probably start getting word out that contracts will probably be coming to the extent you're not already under contractual agreements with some of your vendors, and really having a handle on the data flow when it comes to your third-party relationships. And then really starting once the agency is set up, likely early next year, springtime, we're going to start seeing the regulatory process take shape by the middle of next year. And over the course of the 12 months that follow, really tracking the regulatory process, because as you've seen, a lot is in the regulations and the authority that's going to come from the agency there, and hopefully a lot more helpful guidance for businesses to drive compliance as compared to the experience that businesses have gone through with the CCPA. And then future will be 2023, and that's when you're going to have to work towards updating your notices and privacy policies, et cetera. So
in the regulatory process as well, I think one thing worth emphasizing, right, is to the extent that you were not engaged in the CCPA regulatory rulemaking process by submitting comments to the AG's office, and there are topics here that are part of the regulations that you think are going to be significant to your business operations, really think about engaging in that process. It was clear from the documents that came out, the appendices that came out from the AG's office, when they issued the final regulations and the final statement of reasons, that they thought about a lot of this stuff. And now we're going to have the agency doing them. But I think the issue is you can make changes to the regulations that are beneficial to you, or stop things that might be detrimental to your business interest if you engage in that process. And the ones that we saw that really got the most traction were the ones that were well thought out, that were well processed, well presented to the AG's office. Those made changes, and they made things better for the businesses as we went through the drafting process. I expect that we'll have public hearings. I expect that we'll see draft regulations and that whole process. Again, it remains to be seen how that plays out, but that's going to be something, just don't sit on the sidelines. If there's big ticket items for you, get into the game on that regard. Okay, we are at the almost last slide. We have only remaining the poll questions after this. So for those of you who are not Kansas, I encourage all of you to answer the poll questions if you want, if you're not sick of us already. But before we get to that, I always say this is the shameless plug portion of the webinar. We've got a blog. We've actually referenced it a few times, right? I know a lot of you are subscribed already. You may have found the webinar through the blog. If you're not, I encourage you to do so. We write a lot on CCPA, now CPRA. we're going to write a lot come January when state legislatures open. Malia mentioned Washington. There's already draft legislation there that's been put out. We haven't written on that one yet because it hasn't been proposed yet, right? But we are, you can imagine, when the legislatures start opening up in early January, whatever that looks like in a COVID environment, we're going to be writing a ton on that. And we're going to be tracking on all these regulatory changes. We write blog posts almost immediately when these things happen, do webinars. This is our way to talk to you. So really encourage you to jump on and subscribe to that. I think there's also a function in the question and answer session as well, that the post webinar question section where you can ask to be added. Okay, time for the poll questions. I am told that what I need to do is read the question and then give 10 seconds for people to answer, right? So what type of industry do you work in? This is not a trick question, I should point out. Okay, I feel like that was 10 seconds. Do I answer it? I just next, okay. There we go, a lot of financial services. I wasn't wrong on that. Cool. Next question. Based on what you heard today, do you think, yeah, we're missing a word, the Privacy Rights Act is an improvement on the CCPA. Notwithstanding that, do you think the CPRA is an improvement on the CCPA? And yes, I did take the unsure option off the table here. It's only a yes or no. Yes. Well, there we go. That's hilarious. That's the breakdown of the votes. You guys are lockstep with the California voter. Okay. Do you think that other states will implement laws similar to the California Privacy Rights Act? Yes or no? Okay. Yes. 2/3. There you go. 2/3. So that's it. So we're done. Listen, I think you're right. We need a little bit more than an hour, but I think we got it done an hour and 17. So again, we appreciate you guys being on with us today. Look for the blog, and obviously we'll be doing more webinars in the near term to talk about all things CPRA. And hope everyone's doing well. We'll talk to you soon. Thanks.